and get this pretrial hearing underway. There is Carly entering the courtroom right now. Let's take you into the courtroom.
Carly Gregg, calls number 2024-34169. We're here by way of pretrial conference. All right. We'll begin with docket number 168. State filed a motion in limine to exclude motion of punishment. The defendant filed no response. Granted. Give me an order to that effect.
Yes, sir, Your Honor. One question regarding that punishment as well. The attempted murder statute requires bifurcation both for guilt and sentencing. And of course, we would ask that any comments about sentencing be reserved for the murder and the attempted murder.
For the sentencing things, yes.
Yes, sir.
All right, docket number 169, motion in limine to exclude golden rule and jury nullification arguments. No response was filed. It's granted. State's being in order. All right, motion document number 170, motion in limine regarding facts not in evidence. No response was filed. Granted. Give me an order. Document number 171, motion in limine regarding speaking objections. No response was filed. Motion is granted. Document number 166, motion to suppress urine test. Heard from the state. I read the state's motion. Excuse me, I read the defense's motion. I read the state's response. State's burden of proof. Do you have any witnesses you wish to call?
I'm sorry, Your Honor.
It is the state's burden of proof. Does the state have any witnesses it wishes to call?
Sure, Your Honor. The state calls Corey Gerber.
All right.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. You understand that you know the right answers, four answers of the building?
I do.
You may proceed.
If you would introduce yourself for the record.
My name is Corey Gerber.
And Mr. Gerber, what is your role currently?
I currently serve as the Rankin County Youth Court Prosecutor.
As a youth court prosecutor, do you have experience in information regarding what happens when an inmate is intaked at the juvenile detention facility?
I do.
And is there a policy and procedure put in place regarding drug screening of all offenders once they're taken into custody?
It is the practice of the juvenile detention center to drug test everybody that is brought in. That is my understanding.
And to be clear, could you explain for me kind of the breakdown out at the juvenile detention center? There is the youth part, the court part, of which you're a prosecutor, and then there is the detention part. Is that correct?
They're two separate entities. The juvenile detention center is run by the sheriff. The Rankin County Youth Court is the court, and they are separated by locked doors. We are two separate entities, yes.
Hold on just a second. You can check. It's all right.
Testing.
Mr. Gerber, you said that each inmate is drug screened at admission. Could you tell the court what's the purpose of those drug screens?
My understanding is that every child detainee that is brought to the juvenile detention center is drug tested for the purposes of safety. There are multiple things that are done when a child is brought in. One, they are to meet with a mental health crisis assessor. The other is they're drug tested. And my understanding is that they are drug tested just to make sure that whatever substances are in their body for purposes of medical care.
And are you familiar with the drug screening that's done in conjunction with that?
I am.
Could you tell the board about that?
So those are observed screens. Those screens are taken. Once the screen is done, they are presented to the lab. Then the lab would run those tests. The lab is on site. That is a very expensive piece of machinery. I am not an expert in how that machine is run. I can tell you that that machine is calibrated once a week. Every time that the machine is started before any tests are run, there are controls that have to pass. You have 3 attempts to pass those controls. If the controls do not pass at that time, the machine has to be recalibrated until the controls do pass. Otherwise, we do not run tests.
And Mr. Gerber, do you have any personal knowledge about whether or not that machine was running appropriately on March the 20th of 2024?
I do not have any personal knowledge other than if it wasn't running appropriately, it would not have been running.
So they would not have performed a test if it was not working appropriately?
They would not have ran the test if it was not working appropriately.
You talked about that there's some checks and balances in place and calibration to make sure that the machine is running correctly. How reliable are the results from these particular drug screens?
They're very reliable. If they weren't reliable, we wouldn't use them. We wouldn't waste anybody's time or money doing the tests. I will say they are not confirmed tests. So typically what you have is whenever a urine test is had and you get a result, if that result is a positive test, what would typically happen in a case like that is that urine would be sent off for confirmation. We do not do that. We use that test primarily for assessment, not for any evidentiary value. We are not presenting that information to the court without some other types of discussion.
And so the screening's done for safety. The screening has some checks and balances in place. And you said that the results are very reliable. So if someone had presumed tested positive during one of those screens, like the defendant did in this case, that would be very reliable.
It would be reliable. If there was any question, typically what we would do is send that person for a separate test. Depending on what you're testing for is going to be the question. There are some things that we test for that are not as reliable as others. An example would be methamphetamines. Those are the ones that we typically have the question on. We do send those. We don't send that urine for confirmation. Instead, what we do is send the person out to give another sample and have that sent for confirmation.
Court's indulgence. Mr. Herbert, with regards to the test performed by Carly Gregg, has anyone provided you anything to show that that particular test was not reliable?
I don't recall seeing that test, nor has anyone mentioned that it wouldn't be reliable.
No further question.
Cross-examination.
Thank you, Your Honor. Now, Corey, okay, why was Carly at the youth detention center to begin with?
Under federal statute, a child cannot be detained in an adult facility without an interest of justice hearing being had within 6 hours of that child being detained. So as a courtesy to the judge, Carly would have been at the juvenile detention center until a hearing could be scheduled for purposes of that interest of justice. She was there long enough for that hearing to be scheduled. She was transported from the juvenile detention center to the jail here or to the court. I'm not sure where she was sent after that, but that hearing was scheduled.
Okay, so, because she, according to the statute, she's considered an adult, correct?
Yes.
Okay. And so, my understanding, why is it that everybody is tested in the youth detention center? Isn't there some federal grant that y'all are under that requires that?
I'm not certain whether there's a federal grant that requires everybody be tested or not. Again, my understanding is they are tested out there for purposes of safety reasons.
Okay, so she was only gonna be held there for a few hours until she could be brought over here to Rankin County. Is that
As
correct?
soon as the hearing could be scheduled, correct?
Okay, and so there wasn't a warrant or anything like that to have her do this test, correct?
Not that I'm aware of.
And there was no probable cause where somebody was saying that we want this test done, correct?
I'm not certain. The only thing I can say is that she was tested for the same reasons that anybody else that would be brought to that detention center was tested for.
Okay. But she was an adult and everyone else would have been children, correct? Or youths? Okay, correct?
She would be classified as an adult. She's still a child.
Yes, I agree with you. She's still a child, but she would have been classified as adult.
Yes.
Okay. And so now when you were talking about the test itself, and you said that it's calibrated once a week. Okay. Is there like a logbook that you have that says that it's calibrated?
I don't calibrate it. I just know that the protocol of practice is that it is calibrated once a week, and that's going to be the first start, typically on Monday.
So you don't know if these things are even kept. Is that correct?
Oh, I don't know. I don't. I'm not the person running the machine.
Okay. And the night that this happened, who ran the machine?
I have no idea.
Okay. And if I showed you the test card, would you be able to tell us who ran the machine?
Yes.
Okay. Yeah, approach the witness, John.
Yes, you show the council officer. Anything we're going to show the witness, let's mark that. Can
No objection, Your Honor.
you mark that P1 for identification?
Yeah, that's the test card that we have. In fact, that's the only document that we have concerning this test.
This is the only document. There's no there's no back sheet to this.
That is the only document that we've been presented.
Then no, I can't tell you who ran the test.
Okay. From looking at that document, can you even say that it's calibrated or it's been checked or anything?
I can't. Not from looking at this document, no.
Okay. Now, I guess, once these samples, these samples are given, and you said they're taken to the lab, and the machine's in the lab, is that correct?
That's correct.
And then they're run at that, the samples run at that point.
It is run once the machine is started. So, a better answer for your question, is that if the sample is taken at night and it's placed in the lab will be started by the person that runs the machine when they get there the next morning, and then it would be ran in. So I don't know what time this was taken. I can tell you the date that it was taken based on this. It was collected on the 20th, according to this sheet, and it would have been ran the same day at 9:21.
Okay. And when these samples are, I guess, run, what happens, I guess, is there going to be extra fluid, or is it marked and then it's put in I guess you'll have a refrigerator or something?
So yes, we do have a refrigerator, but no, the extra fluid is disposed of. We do not keep the urine, not to my knowledge.
Okay, so you run this test. So let's get back to this, where you say you use the test for, because the test is for the youth court, basically. Is that correct?
Well, it depends on the case. I mean, yes, I mean, if this child were to be a child under the jurisdiction of the youth court, this test could be used for multiple things. One, to give the detention staff an idea of what is in that child's system for purposes of maintaining the child at the juvenile detention center. The second could be for purposes of disposition. The youth court is a court of rehabilitation, and we want to address the whole child. So if I see this particular test, I can tell you that it's positive for cannabinoids in an amount of 237.7 nanograms per milliliter with a cutoff of being 20. That would indicate that this child has consumed some type of cannabinoids. We would want to know that moving forward for purposes of A&D assessments and possibly enrolling them in some type of program to address cannabinoid use. If there is a question as to whether or not this is accurate, what would happen at that point is we would send that child for something else. But these tests are reliable, they're just not confirmed. So there is no, I would not use this as an evidentiary test.
Right, and that's what I'm getting at, is an evidentiary test to say that is actually what it is. That's not what you use them for, and that's not what they're designed to be used for, correct?
That's not what I use it for. Again, this is just an assessment tool used by the court for purposes of disposition. In the event that there's no contest between the child or the person, the donor, sometimes adults get these tests. If there's no contest about what is found in these tests, at that point they can be submitted to the court. But I do not submit these to the court for evidentiary value and adjudication.
And so where we're at right now is, you said they're calibrated. There's no calibration documents or anything that I provided you or that you have in front of you, correct?
I don't have it, no. You haven't provided it.
And I think the only thing I gave you is a test card that was given to us.
That's correct.
Okay. And so that doesn't tell who did the test. It doesn't say if the other safeguards have been done on the test. It doesn't, is the person even qualified who ran the test? We don't even know that, do we?
I will tell you that there are only certain people that are allowed to touch that very expensive machine. They are all qualified to run it. But I can't tell you who did that particular day. As to your other question, it was collected by someone in the Rankin County Sheriff's Department. So that would be a detention staff, but I do not know who that would have been. That information can be gathered, but I don't have it.
No further questions, Chairman.
Can I read the exhibit with my court reporter?
Yes. I'm trying to steal your exhibits.
Read away.
Raise your arm. Mr. Gerber, as I understood it on cross-examination, you said these tests are for, again, safety and medical purposes for the detention staff as well as the donor?
As well as disposition. In the adult world, that would be sentencing. We want to make sure that we have all the information available to us to make sure that the rehabilitation process, it happens. So they have multiple uses, yes.
When the detention center finds someone is tested positive for a substance like Ms. Gregg did in this case, why is that important for them to know from a safety standpoint?
Well, for example, if it had been fentanyl, we would have taken the child directly to the hospital. The other is we want to make sure that there's no interaction with anything else that's going on. I don't work in the detention center. I don't want to speak for them, but I mean, I think it's fairly obvious that we want to know if the child is under the influence of any type of drug while they're in the detention center.
And if the child admits that they've used drugs, would that tend to corroborate the test results as well?
Yes.
Do you have any information that Ms. Gregg did not corroborate this test as you sit here today?
No, I don't have any information.
No further questions, Your Honor.
Stand down. State may call its next witness.
No further witness, just an argument, Your Honor.
Defense have any witnesses that wish to call on this issue?
No, Your Honor.
All right, argument by the state.
From here, the vote, Your Honor. The state outlined in our response and then filed an amended response. I want to bring that to the court's attention. Initially, we believed that the Juvenile Detention Center was under a particular grant through the OJJDP, which is the Office of Juvenile Justice and Delinquency Prevention, that federal grant does require drug testing. Upon communications with the Board of Supervisors, it's actually a different grant than we initially cited in our response. So I did file an amended response attaching the appropriate grant that does in fact require drug screens of all offenders at entry. or that does require, drug screens, as well as the Rankin County Sheriff Department's Juvenile Detention Center Policies and Procedures 2.2F. Those were provided to me by the Sheriff's Department, which again outlined that each offender is screened there at the detention center immediately. It also outlines the policies and procedures that are to take place upon entry. These screens, as you heard from Mr. Gerber, are very reliable. The state is not attempting to use this screen for quantification, rather for presumption. As pointed out in our response, the defendant has admitted during particular evaluations and through other witnesses that she did in fact use marijuana. She has said that she used it during her assessment with Region 8 as well. She says that she smoked it. This happened on the 19th. She says that she smoked it on the 18th at least. We believe that this information is certainly pertinent since she has asserted her right to claim an insanity defense. As this court's well aware, in cases such as Crawford v. State, once the defendant puts their sanity at issue, the door is thrown wide open for the admission of evidence of every act of the accused's life relevant to the issue of insanity or sanity and is admissible in evidence. That's Crawford v. State, 867 Southern 2nd, 196. Additionally, Mississippi Rules of Evidence 703 states that an expert can rely on facts and data that are not necessarily admissible in evidence. And so our doctor, Dr. Pickett, has relied upon Carly's admissions of using marijuana as well as this presumptive test to show that is and does call into question her mental state. As this court is also aware, voluntary intoxication is not a defense to murder. It does not entitle you to an insanity defense. And so we believe that 703 as well as Crawford and the admissions by the defendant make this test even more reliable. This isn't just a piece of paper that shows that she had marijuana in her system. We have the defendant herself saying that she'd smoked marijuana at or around the time of the crime, as well as additional witnesses that we intend to introduce. As outlined in our arguments, we also believe that this urine screen is akin to the DNA buccal swab found in Maryland v. King. There was a 3-part test. We believe that it's similar in that the Rankin County Detention Center's booking policies require that all offenders be screened, that urine sample is the least and minimally invasive drug screen that's available to them at the time. And as such, we believe that the drug screen itself should be admissible under Maryland v. King. Also as cited in our arguments, and what Mr. Gerber talked about today was that these tests are done for the safety of both the offender as well as the facility. And we believe that that record is actually a part of Carly Gregg's medical records. And because of that, and because of her claim of insanity, she has waived all medical privilege with regards to anything that might have to do with her mental state at the time of the crime. Specifically, we cite to Rule 503F of the Mississippi Rules of Evidence, as well as the cases outlined in our response. We ask that the state be allowed, that our evaluating psychiatrists be allowed to review and talk about the results from this urine screen as they do affect the defendant's mental state at the time of the crime. And then additionally, we would argue that if a search warrant was required, Holloman v. State would apply. In this case, it was a drunk driver who killed someone driving in a car. Law enforcement was on the scene. They observed the presence of beer cans, empty syringes, and bottles containing unidentified liquids. At the time, the person's blood was drawn, and also a urine sample was taken. There was the presence of methamphetamines and cocaine. This sample was taken without a warrant, similar to what we have here, and the court found that a warrantless search is permissible in certain exigent circumstances if it can be shown that grounds existed to conduct the search that, had time permitted, would reasonably have satisfied a disinterested magistrate that a warrant should be properly issued. And similar to Holloman in this case, the substances that were in Ms. Gregg's system at the time can dissipate over a period of time. And this screen was done on the 20th. She was brought over hours later. And we would argue, Your Honor, that if a warrant was got, if we had received a warrant, had to serve it on her and get an additional sample, that would be even more far removed than this sample was on the 20th rather than the 19th at the time of the crime. We would, of course, also state that, as pointed out, it's going to come into evidence that Ms. Gregg was using marijuana. And we believe that if it doesn't fall under the warrantless search and for the safety and within her medical records and the alternative, the state would argue that this would fall in the inevitable discovery doctrine. And admittedly, under that doctrine, you have to show that law enforcement, there was some misconduct, and that but for the misconduct, these items would have come forward. There's been no such misconduct in this case. However, there is a test that outlines when things would come into play if it was inevitably discovered. And we believe that's the same thing with a shearing screen. Based on admissions by the defendant as well as other evidence, law enforcement had at the time in their possession illegal substances, the presence of the vape pens that they had seized from the house, and knew of the fact that there may be a potential for drugs to be in her system. We would certainly ask, Your Honor, to consider all of those exceptions and rule that the urine screen would be admissible for its purpose of showing that marijuana was in fact in her system and not for a quantitative state.
Response.
Thank you, Your Honor. First of all, Your Honor, I'm just going to briefly touch base. The state brought up the fact of basically the indigent circumstance where you can draw blood. The Supreme Court of the United States changed that in McNeely, Missouri versus McNeely in 2013. You now have to have a warrant. So when the state's saying that you do not have to have a warrant in that type, like in the Holloway situation, that was a different time. That was okay at that time. That would have been under the Shoemaker ruling that said that there were exigent circumstances and that you could get away with not having a warrant. That has now changed. The one thing I want to say is that with this charge, Carly was charged as an adult, and she was taken to the youth detention center, and it puts her in a different status than most people that are going to the youth detention center. Most of the people that are going to the youth detention center are being handled as youth. In fact, I would say all of them except a very small, minute amount. In Carly's situation, she's entitled to due process, which is there has to be a warrant, there has to be probable cause, there has to be some of the protections built in. They bring up the Maryland v. King case, and they say, well, in Maryland v. King, there was actually a state statute that mandated certain testing. And the Supreme Court was looking to see if that was viable, if that was a viable law. And they came back and they said, yes, that there was it validated the law. It said that there was a judicial reason for them to have the law, to have the testing. So therefore, what they did in Maryland versus King was okay. That's not the type of situation that we have here. There is no Mississippi law. There is no federal law that says that this shall be done. This is just the policy and procedure of the Rankin County Detention Center. And so what's happened is she's entitled to due process, and that didn't happen in this situation. There is no probable cause. There is no warrant. That was testified from the stand. The next thing that I want to bring up and put to the attention of the court, in order for a test to be valid, you have to have the person, and this is under Mississippi law, and this is any of these chemical tests, you have to know who the person is performing the test. You have to know the testing procedures. It has to be laid out somehow, and it has to be presented to the court and say, hey, this is done. And then the last thing is there has to be something to show that it's reliable. The way they show that it's reliable is having calibration records. You have the information of who did the test, how it was done, when it was done, and it was done according to the way the test was supposed to be carried out. We don't have any of that. The only thing that has been presented to us is a one-page paper, and on the bottom of the paper, it's document 1 of 1. It's not 1 of 10 or something like. There's a whole bunch of other documents that go with it. You have a test card. The other thing that comes into play is the state is wanting. They say, well, first of all, the test is not designed to be a standalone test. It is not to say what you're seeing in that test is what's in her system. It's only an identification test. They use it for that purpose. They do not use it for evidentiary purposes. What the state's wanting to do is take that test and then turn it into evidentiary purposes. They say, well, we just want to have it as like an identification kind of thing. Well, no, they're wanting to, in their reports, they're going in and trying to say whether or not she's under the influence at the time based upon that test, which is an invalid test. It does not show, it doesn't meet any of the requirements of being a valid test by how it was done, who did it, was it calibrated, did they follow the protocols? None of that stuff. None of it has been provided to us. And also, there's been no consent. There's been no testimony if there's no consent. No consent, there's no warrant. The test wasn't done right. It's being used for a different purpose than what the youth detention center uses it for. For all those reasons, Your Honor, we ask that the test be excluded at this time.
Mr. Mackey, your reply.
Yes, sir. I believe that Missouri versus McNeely deals with warrants for blood draws, and in this case, we're talking about a urine screen. Also, Mr. Camp mentions the laws in Mississippi and the statutes about calibration, and I believe what he's referenced it to is the implied consent law, which talks about intoxilizers, not the drug urine screens. Again, we believe that this does fall within the exceptions as cited in our amended response and also argued today. And more importantly, we believe that it falls within Ms. Gregg's medical records upon which she's waived any privilege to, as well as under Rule 703, and that our experts should be allowed to rely upon the presence of marijuana in her system at or near the time of the crime, including the day after the offense, to render his opinions regarding her mental state at the time. We ask that the urine drug screen not be suppressed in its entirety, Your Honor.
All right, the court looked at several different cases, in particular Skinner, Von Rath, Vernonia, Maryland versus King. In addition, the court also read Chandler versus Miller, and Ferguson versus City of Charleston. In this particular case, because the need for a warrant is greatly diminished here, where the arrestee was already in valid police custody for a serious offense, supported by probable cause, the search is analyzed by reference to reasonableness, not individualized suspicion. Reasonableness is determined by weighing the promotion of a legitimate governmental interest against the degree to which the search intrudes upon an individual's privacy. The court would find that the government has there's a legitimate governmental interest in determining whether or not somebody is under the influence in the juvenile detention center, not for the purposes of prosecution, but for the purposes of safety of the accused. Obviously, like Mr. Gerber testified, if somebody tested positive for fentanyl, there's serious withdrawal issues. Well documented. It's not hard to find that out there. I'm not sure the juvenile detention center is equipped to handle those type of situations. That's a valid governmental reason to do it. Looking at Skinner, Von Rath, and Vernonia, the court believes that falls into that. Additionally, the court looked at Jones versus State, Mississippi case cited 881 Southern 2nd 209. the physician-patient privilege was waived in this particular case. And in Jones, the evidence was actually used to prosecute the person. That was not the intent of this evidence. The intent of this evidence was to find out whether or not there was a critical medical need that needed to be assessed at that moment. Now, the court would have a different holding if the state was attempting to offer this to prove possession of cannabinoids or some other crime, but that's not what it's being offered for. In retrospect, the state was able to go back and look at that and raise it for the defendant's insanity defense. So for those reasons, in the case law cited, Maryland versus King, the court would also find that a urine analysis is the least invasive and most reliable method to obtain a drug screen. A needle would be very invasive. Buccal swabs are not considered to be very reliable with saliva type testing. Hair testing is invasive. You're retrieving a piece of hair from the child's body. And in addition, the reliability of those in short periods of time are not where they need to be, so to speak. It shows too great of a window. So for those reasons, the court is going to deny the motion to suppress. However, the court is going to restrict the state. You're not to get into this in your case in chief. It can only be used if and when the defendant raises their insanity defense. That'll be the court's rule in states to give me an order. All right. Next matter was a motion for gag order document number 177. The response was filed late. As such, it will not be considered. Motion for gag.
And we are back. And sorry that we have to cut out in the middle of that, but we are continuing to follow this. But we do have our first alert weather team that is about to be coming on here and giving everyone an update on currently with Tropical Storm Francine to possibly become Hurricane Francine before it makes landfall in Louisiana tomorrow. So we are going to jump off of here real quick. Make sure you tune in to Wlbt tonight, all of our newscasts, to not only get your updates there on the storm and as it's coming our way, but also to hear exactly what all has happened today in the pretrial hearing for Carly Gregg. Again, her trial is set to start next Monday, and Wlbt and Wlbt Plus will be there, and we'll have you there with us. We're going to jump off of here for right now. When we come back in just a few minutes, our first alert weather team will be here to go over a detailed forecast tracking the tropics.